The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning. The next case is Crazie Overstock Promotions, LLC versus State. I'll note that Justice Berger is recused in this case. That being said, we'll hear from the appellant.
Good morning. May it please the court, my name is Keith Anthony. I, along with my colleague Bill Bryan, represent the plaintiff appellant Crazie Overstock. We would like to reserve 5 minutes of our time for rebuttal, which Mr. Bryan will handle. Mr. Bryan is here with me. We are sharing a similar computer, so he will use the computer for the rebuttal. We are asking the court today to reverse the Court of Appeals holding that the Crazie Overstock rewards promotion violates North Carolina General Statute 14306.4 as a matter of law. I think the starting place for this argument is the proper standard under North Carolina General Statute 14306.4, which I'll refer to as the Sweepstakes statute. The question is whether the predominance or predominant factor test applies to this Sweepstakes statute. That test applies to the other gambling related statutes. But if we look at the plain language of the Sweepstakes statute, it's our position that a different test applies, that it's not the predominant factor test. But just a point of housekeeping that regardless of which test applies, whether it's the predominant factor test or the test that we believe should apply, that the state is not entitled to summary judgment under either of those standards. We begin with looking at the plain language of the Sweepstakes statute to determine which test applies. This court has said over and over again what the rules of statutory construction are, and just repeated those not even 2 weeks ago in a recent decision involving the city of Concord that was issued. Those rules of statutory construction make clear that we have to give meaning to all of the words that are used in a statute, that none of those words are to be rendered meaningless by any interpretation of the statute. And here, if we apply the predominant factor test, it would have the impact of rendering certain language of that state statute meaningless, particularly the dependent on skill or dexterity language. And so I think as the starting place, when you look at the Sweepstakes statute, you look at the definition of a sweepstakes. The definition of a sweepstakes makes clear that a sweepstakes is a game of chance. It specifically says that a sweepstakes, any game, advertising scheme or plan or other promotion which, with or without payment of any consideration, a person may enter to win or become eligible to receive any prize, the determination of which is based upon chance. Not all sweepstakes are illegal under the Sweepstakes statute, only certain ones are. And the ones that are those that are conducted through an entertaining display. And the statute goes on and defines what an entertaining display is. And relevant to this are really one or two particularly specified types of games. These are video games that do not involve skill or dexterity, that are not dependent upon skill or dexterity. That skill or dexterity language means that you can have a game of chance that is unlawful if it is not dependent on skill or dexterity. So if you conduct a game of chance, a sweepstakes, through a video game that is not dependent on skill or dexterity, then it violates that statute. The converse is true, that if you conduct a sweepstakes, a game of chance, through a video game that is dependent on skill or dexterity, then it does not violate the Sweepstakes statute. So you can have a game of skill that is lawful so long as it is also dependent upon skill or dexterity, which means you can't.
Excuse me, Mr. Anthony. Before I lose my train of thought, and following the point that you're making that every word in the statute needs to have meaning, using your analysis that you just said that conversely, a video game based or involving random chance or whatever that is dependent would not violate. How do you give meaning to the phrase in the upper part of the statute that says by way of illustration and not exclusion? Isn't it possible that there could be a video game that is dependent on skill or chance, but still doesn't meet the statute? And if not, could you explain why?
Yeah, and so, I mean, you're correct that these examples are specifically by way of illustration and not excluded. However, the specific language still matters. The fact that the General Assembly included this language about dependent on skill or dexterity was a conscious and deliberate decision. And there's a legal principle that you know that the inclusion of one thing infers that the things that are similar are intended to be excluded. If the point was that this applies to both games that are dependent on skill or dexterity or games that are not dependent on skill or dexterity, what the General Assembly could have easily done and should have done, if that's what it was intent, was to just remove the language altogether. Or it could have alternatively said, regardless of whether skill or dexterity is involved. But the fact that they chose that specific language suggests that it has some specific meaning, and we've got effect to particular. And so position here is that the predominant factor test does not apply. What you have to look at is the final outcome, and that's consistent with the Sandhills decision from 2014, is that you look at the final outcome. And what does that mean? And whether you are entitled to get a prize. You know, if a participant exercises skill and dexterity, and that through that exercise of skill and dexterity is able to get a prize, then they satisfy the requirements of this sweepstakes statute, and what they're doing is not illegal.
All right, Mr. Anthony, just so I understand what your argument here is, are you saying in effect that as long as skill and dexterity has anything whatsoever to do with what happens, it's legal?
No, I'm not.
Okay, what are you? I'm having a little bit trouble figuring out exactly what it is you say this statute means. Enlighten me, if you would.
So the question is, what determines the final outcome of the sweepstakes? What determines whether or not a participant is eligible to receive a prize?
And by that you mean any prize regardless of its size? Correct.
Because the sweepstakes.
So basically, again, I'm sorry, I have discovered over the years, if I have Justice Berringer and I both refer to the lost train of thought, and I want to make sure I'm not losing mine here. So your argument is as long as a person can get any prize, no matter how small or how large, that takes the statute, takes the sweepstakes out of the operation of the statute?
Correct. So long as the way to get that prize is through the exercise of skill or dexterity.
So that in the event, I mean, hypothetically, and I'm not enough of a mathematician to try to do this correctly, but let's say for purposes of discussion that the amount of the prize is 99% determined by chance and 1% by skill and dexterity. That is still not a covered, a prohibited sweepstakes for purposes of the statute.
If you're talking about the amount of the prize, if chance determines the amount.
I'm sorry. Yes, that's what I am talking about. Sorry, Mr. Anthony.
Yeah. So our position is that skill determines whether you receive a prize. It's fine that chance determines the amount of the prize, and chance can determine the amount of the prize 100%, so long as skill determines whether or not you get that prize. And the reason we make that distinction is that you have to look at what a sweepstakes is. A sweepstakes, by definition, is a game of chance that determines the value of the prize. That's the language of the sweepstakes. And so a sweepstakes is a game of chance. The prizes always vary in a sweepstakes. chance determines what the value of the prize is going to be. But in order to comply with the language of the statute, skill has to determine whether or not you're entitled to receive that prize. I believe that's
Mr. Anthony, could you clarify for me from a factual basis, what is the range of the size of the prizes you're talking about?
specific to the Crazie Overstock rewards promotion.
Yes.
Everyone has the opportunity to win at least $1. So that's the minimum prize is $1, that everybody who participates in it has an opportunity to win that. There are certainly larger prizes than that. I do not know what the highest dollar amount prize is.
I mean, it's conceivable to answer Justice Barringer's question in more detail. It's conceivable that you could get a $200 prize out of this, depending on the results of the.
Yes, it goes above that. I'm not sure what the top dollar prize is, but it's hundreds, if not, there may be a prize in the thousands.
Okay. So it could be from $1. It could be from $1 to several hundred, or even more than that.
Do you have any? Do you have any statistics on what percentage of those prizes are $1 prizes?
I do not have that. I don't believe that's specifically in the record.
Thank you.
So
let me ask you something before I lose my train of thought about the test that you've said we should apply. You said it's not the predominant factor test, but it's the final outcome, whether it's determined by chance or skill. And my question is, where does that test come from? What's the authority for that?
Comes from the language of the statute. We've got to go to the statute itself. And so, as I noted earlier, we've got sweepstakes is defined as a game of chance. There is a carve out if you're conducting that game of chance through an entertaining display that is a video game that is dependent on skill or dexterity. So we have this language dependent on skill or dexterity, and how do we construe that? I'm construing that final outcome based upon the 2014 Sandhills decision. In Justice Irvin's opinion that he wrote, he talks about looking at what the final outcome is, what controls the final outcome. And I believe that, in fact, is the appropriate test in analyzing whether or not that sweepstakes is consistent with this sweepstakes statute or not.
But again, the final outcome is simply, is there a prize at all without any attention being paid to the amount of the prize?
Correct. Whether the participant has the opportunity to win that prize. Because in the 2014 Sandhills decision, that was not the case. There were a number of situations where participants could be very skillful but had no opportunity to even exercise that skill. By being able to exercise that skill every time brings you into compliance with the sweepstakes statute. So that's our position, and we think that the trial court of appeals applied the wrong decision. But even if you do the predominant,
Mr. Anthony, before you leave this thought, you have quoted Justice Irvin, and you mentioned whether skill or chance determines the final outcome, but you didn't quote the final part of that statement, and whether chance can override or thwart the exercise of skill. How do you address the fact that you've got this random prize situation, many of which we don't know how many, are $1 prizes? That is a chance element that's involved in the game. And so how do you reconcile that with your outcome analysis?
Sure. Again, it goes back to the definition of a sweepstakes. A sweepstakes, by definition, is a game of chance in which you have different prizes. And that comes just from the definition itself, which says, a person may enter to win or become eligible to receive any prize, the determination of which is based on chance. So the sweepstakes statute does not make legal all sweepstakes. It only makes those sweepstakes illegal that are conducted through an entertaining display. And so we get to that language about dependent on skill or dexterity. And so the prize really doesn't matter that chance determines the value of the prize. The question really becomes then, what determines whether the participant has an opportunity to win that prize? so long as they can exercise skill and dexterity every time to win that prize, regardless of value, it complies with the sweepstakes statute. So that's really the difference between that and the predominant test, which the predominant factor test, predominance test, looks at the total amount of chance that you have on one hand, including the amount of chance involved in determining the prize, compared to the amount of skill and dexterity involved. And here, even if you apply that test, and again, we don't think it's the right test, but even if you apply that test, the state is still not entitled to summary judgment. We have chance playing an entirely independent role and skill playing an independent role. It's one thing when, as you noted, Justice Berenger, that chance thwarts the exercise of skill. When you have that, when chance prevents you from being able to exercise skill to be successful at the test, then you can say that chance as a matter of law overrides skill. But we don't have that here. In the Crazie Overstock rewards program, you've got one element of chance and you've got an independent element of skill. And so the court is going to have to weigh those to determine, or a trier of fact rather is going to have to weigh those to determine which one is the predominant factor. And here we have a number of elements and facts that go to that issue, which a trier of fact must consider. We've got evidence that ALE, when they did undercover investigations, they applied for search warrants in order to conduct raids. When they went to the trial court judges to ask for those search warrants, they omitted all reference to the dexterity test, even though they had to go through the dexterity test to get a prize. In fact, they said there's no skill or dexterity involved. They intentionally omitted it because they realized that would perhaps create some issues as to whether they could get a search warrant. We have another case involving Crazie Overstock where the trial court judge granted a motion to suppress because those search warrants didn't contain that information. So had the search warrants contained that information, they would not have obtained it. There are criminal trials in which there were not guilty verdicts that were entered related to the Crazie Overstock rewards promotion. So there are a number of examples where reasonable triers of fact have looked at this and they have weighed it and they have said that this is a skill game rather than a game of chance. And so when you take these two elements and you have to decide which one predominates, at that point, we are looking at a jury issue and not a legal issue. And therefore, the Court of Appeals and the trial court were incorrect to hold that state is entitled to summary judgment.
How is it that chance does not thwart skill if a player can exercise excellent or perfect dexterity or skill and yet not be eligible to get the premium prize if chance prevents that from occurring based upon the selection of the prize by the machine?
Right. Again, it goes back to our, the definition of a sweepstakes. A sweepstakes, by definition, determines the amount of the prize. Chance determines the amount of the prize. So that's what chance is going to do. The General Assembly has not said that all sweepstakes are illegal. Only certain kinds of sweepstakes are illegal, and those are sweepstakes that are conducted through an entertaining display that are not dependent on skill or dexterity.
Do the machines at issue here employ an entertaining display?
No, not under the statute, because the statute says that video games that are not dependent on skill or dexterity are prohibited. Therefore, video games that are dependent on skill or dexterity are not prohibited, are lawful. And these video games here, they are video games. We're not disputing that they're video games, but our position is that they are dependent on skill and dexterity, and therefore they are not barred by the statute. And I think it's important to keep in mind that any participant in the system, they get these entries free of purchase. They can get them simply by going in and asking, or they get them with the purchase of a gift certificate. If they purchase a gift certificate for $10, they always have the value of that gift certificate, even if they only get a play for the minimum $1 under the rewards promotion. So
how should our analysis be affected at all in terms of the aspect of this gift certificate or product that is available yet not being redeemed because the main thrust of the player is to be able to play the game in terms of the outcome potentially of getting a cash prize?
Right. So that's the second issue. And I'm glad you brought that up because that's the other point that I wanted to get into. And that is whether or not the sweepstakes is pretextual, or whether or not this is pretextual gambling, or whether or not this is subterfuge. I mean, you can look at it either way. Here, at worst case, that is a jury issue to be decided. It's not an issue to be decided on summary judgment under these particular facts and circumstances. And so I think the starting place when you look at that analysis is whether or not you are starting out with a legitimate product that is being offered for sale. And that comes from the American Treasures case, in which the court looked at a phone card and said, this is a really competitive rate. This is a legitimate product, and therefore found that it didn't violate the gambling or lottery statute at the time.
So again, to make sure I'm understanding your argument, Mr. Anthony, it is in essence that as long as a legitimate product is available, regardless of whether anybody elects to buy it, that precludes a finding of that the business is essentially a sham.
No, I think that's the starting place, but that's not the only factor. There are multiple factors that you consider. And again, I think a jury ultimately has to consider all of those factors. But the starting place is, are you offering a legitimate product? And here we are. There's no dispute that you pay $20, you get a $20 gift certificate. That there's hundreds of products that have been available on the Crazie Overstock website that changes from time to time. Those products are competitively priced. That's what the record establishes. There's no evidence to the contrary, that the cost of shipping is competitive. Again, there's no evidence to the contrary of that. These gift certificates do not expire. So you've got a valid product. Then you look at a variety of other factors beyond that. And one of the factors that you can look at is the usage rate. To say, okay, well, is this pretextual based upon this amount of usage? And here, there's a number of things that the trier of fact is going to have to consider, and things that were not before the trial court. I mean, there was some evidence about breakage. It's a reason why gift certificates are sold everywhere that you go. You find them in grocery stores, you find them in drug stores, convenience stores. A lot of people purchase gift certificates, but don't necessarily end up using them, or they don't use the full value of them. So there's evidence in the record that Starbucks in 1 year made over $40 million in breakage from the sale of unused gift certificates or gift cards. And so those are factors that you need to take a look at.
Is there any evidence as to what percentage of Starbucks income was derived from such, I think your word was breakage?
It was $40 million in breakage.
Do we know how that relates to the overall revenues of the company?
We don't. There's limited information in the record on that right now.
Okay. All right. Thank you.
So there's those sorts of things that you need to consider. You need to consider Crazie Overstock's records, and I'll bring that up real quick because the state makes an argument about that we don't have the right kind of records, or that if you look at the records and you look at the dollar amounts involved, it shows a very low usage. As pointed out in our brief, there's a problem with the state's argument with regards to that. The state requested those documents, which Crazie Overstock produced right before the trial that was supposed to take place in this case. The state did no depositions. They didn't take any depositions of anybody at Crazie Overstock. And the state and the state's attorneys, it's the state's counsel that is trying to interpret and construe those documents to say that this is what they mean. Yet the state doesn't have the personal knowledge to be able to explain those documents, isn't able to explain certain things about Crazie Overstock's business that might impact those numbers, such as operations in other states, and in terms of how free sweepstakes are dealt with and handled, and how those are reflected in these documents. This is not opinion testimony. This is testimony of counsel that's saying, hey, we've looked at these records and this is what we believe that they mean. That's not a basis to rely upon for summary judgment. So you have to look at all of this evidence as a whole and try to figure out whether or not this is a legitimate business. We have a lot of evidence in the record that also shows that Crazie Overstock operates as you would expect an online retail store to operate. It's got the kind of website that you would expect to see with the product information and descriptions, with the shopping cart and the save for later. It has all the information clearly available and categorized. We do drop shipping, which the state says, oh, that's sort of a sign that we're not acting the way we're supposed to. Drop shipping is a very common way in which you lower your overhead by not maintaining all the stuff yourself. You actually purchase it from another provider and then you send it to your customer. You know, our evidence from our experts shows that that is a common form of business that a lot of people engage in. So when you look at all of this evidence, it shows that we're operating as a legitimate business.
And Mr. Anthony, before your time runs out, I want to make sure I heard something you said earlier correctly. When you get a free play, is there any limit on the prize you could get in that free play? How does that work? I want to play your game for free. How do I do that? And how much can I win?
It works exactly the same as any other, any way that you acquire the entries into the sweepstakes, it works the same way. There's no distinction depending on how you acquire your free entries. It's free entry if you go and simply ask for free entries, or if you purchase gift certificates, those entries are still free. It's free with purchase or free without purchase. But regardless of whether you pay money or not pay money, the sweepstakes operates the exact same way. It doesn't have any impact on your chance of success in the reward games, and certainly no impact on how you do in the dexterity test.
And I would be able to get the full prize, the big prize.
That's correct. Yes, Your Honor. All right, we'd like to reserve the rest of our time for rebuttal.
Thank you, counsel. We'll hear from the appellee.
May it please the court. My name is Olga Vysotskaya de Brito. I represent state defendants. And Crazie Overstock scheme is unlawful for 3 reasons. First is it offers a game of chance that it's unlawful under section 306.4, which prohibits sweepstakes that is conducted through video games of chance. In this scheme, chance permeates every single feature of the sweepstakes. And critically, chance and only chance can decide whether a player is ever able to get anything more than $1 in prizes. So chance predominates any skill. 2, we also ask the court to find that Crazie Overstock sweepstakes is illegal as pretextual gambling under other North Carolina gambling statutes. It's a pretextual gambling when the products that are being promoted by business are not actually used in any particularly big numbers. So basically what customers do in those situations, instead of buying valid products, they place bets with a hope to win a big prize. And that's exactly what the situation here is. And the record is clear on that point. Plaintiff's own record proves that gift certificates are not being used. And 3, we also find the court to, we also ask the court to find that Crazie Overstock schemes violates also statute that prohibits video gaming machines that are based on chance. So on the first issue, it is interesting, and it is different than the arguments that I heard before in case right before this. Basically, here plaintiffs are proposing an entirely new test for evaluation of whether the Crazie Overstock scheme is lawful or not. What they say is, don't look at the predominance, don't look at what other gambling statutes look at, don't look whether chance predominates any skill. Instead, court, look at what the final element of a sweepstakes design is. And if the final element of the sweepstakes is based on skill, that's it. The sweepstakes is then legal. That is the language, and that is the test, you know, that is entirely divorced from reality, that is not grounded in any statutory language, that is entirely contradicted by the legislative intent, the legislature, when the statute was passed, was very, very clear why it was passing it. The reason was because the sweepstakes operators, under a pretense of engaging into pretextual schemes of into pretextual legitimate businesses, got a bunch of court decisions that held that the schemes were legal. The legislature sought to stamp out such outcomes. It sought to prohibit any type of pretext. So if you were to interpret the test the way that plaintiffs ask you to interpret, where as long as skill is offered at the very end of the sweepstakes, that would entirely undermine the legislative instructions for the court to avoid pretextual constructions of these types of businesses. And of course, Sandhill does not hold what plaintiffs argued. It actually says. Sandhill does not state for a proposition that the final outcome, the final feature of a sweepstakes design is what determines whether a game, whether sweepstakes legal or not. Sandhill stands for a proposition that the same test that applies to other gambling situations in the state should apply to evaluation of video sweepstakes statute too. Justice Irvin was very clear in his opinion in Sandhills. He stated that the trial court's job is to first evaluate whether sweepstakes operators' equipment facilitates a game of skill versus game of chance, as is evaluated in other gambling situations. And after that distinction has been made, then the trial court's job is to evaluate whether the sweepstakes in question falls on one side of the line, whether it's a game of chance or whether it's a game of skill. So Sandhills does not say that final element is the right test.
Does the mixture of chance and skill at all mean that a game will be considered to be a game of chance under the law?
So predominance test presupposes that there is possibly or almost always some kind of element of skill that could appear in any gambling device. And Justice Rufin in some of the older cases, in Gapton and Lipkin, discussed the kind of skill, the kind of skill versus chance that may appear. For example, it is clear that, it is clear that even a game of skill may feature an element of chance. There could be a bluff of wind, for example, in a game of skill, but that does not make a game of skill into a game of chance. Or there could be a gravel in the roadway that could change the outcome of an otherwise game of skill. And that does not change the fact that the game would still remain the game of skill. And so the same is similar when you are evaluating whether a game is a game of chance. An element of skill could, of course, exist. And the first Sandhill decision demonstrates that nudging, for example, was an element of skill. But that did not change the inherent nature of that game. The inherent nature of that game was still predetermined by chance, not by skill. So the mix is completely fine. What the court is supposed to evaluate is what predominates. And in this, in Crazie Overstock system, it is clear that chance predominates. And let me cite why it is so clear. Justice Urban, if you are asking a question, you are on mute.
If I understood Mr. Anthony's argument correctly, he said in effect that as long as skill determined whether you got any prize whatsoever, that rendered the game itself a game of skill rather than a game of chance, and that the magnitude of the prize that you won had no relevance to that outcome. What's your response to that argument?
It is clearly not a correct argument, and for several different reasons. First of all, it is not correct because the legislature sought to eradicate that specific type of play that sweepstakes operators are engaging into by trying to camouflage, throw element of skill here or there. Let's throw it at the end. Let's throw it right before you get a chance. That's what the legislature sought to eradicate when this statute was enacted. But it is also incorrect under the existing gambling laws. In state versus law, for example, there were goods that were being distributed by slot machine. And you were always guaranteed you would get some kind of a prize. But what you did not know was it would be 5-cent prize or 50-cent prize. So of course, the fact that you could get something always does not change what otherwise a game of chance into a game of skill. And also, Your Honor,
does it make any difference to you that they do give away the opportunity to play with full potential for prizes, as the appellant's advocate shared?
it makes no difference. First of all, it makes no difference because in animal protection society, the appellate courts have already stated that, the fact that somebody could get a free entry does not change an otherwise game of chance into a game of skill. So you could get free entries, but many other people, in fact, do pay to get more entries. And the more money you pay to get gift certificates, the more entries you receive. So it doesn't.
Am I correct in understanding, and if I'm not, please tell me, but am I correct in understanding that the biggest prize you could get with the free entry amount was $1?
Yeah, that's not quite correct, Your Honor.
Okay, well, tell me what is correct then.
Okay, so what you get with the free entry is 100 game points to play these casino style games.
Right.
But when you play that 100 points, you could win more than $100 points in order for you then to go to the next element, to the dexterity element. So you could get 100 entries and you could win 200 reward points. Those 200 reward points may entitle you to win up to $2, for example. But that's what's important here is not the fact that there are free entries. What's important here, and Animal Protection Society holds so in many cases from other jurisdictions, Vento, Telesweeps, also had situations where free entries were offered, but many other people pay to get more chances to participate in these casino style games.
And the more, at least, is it mathematically correct that the more chances you have, the higher your upside potential is?
The more chances you get, the more chances you have to win in casino style reward games.
And really the way to get more than 100 starting chances is to buy the certificates.
That's exactly right. And two ways, you could get 100 points, which allows you to play 3 reward games, casino style games, for free once per day, or you could mail in a card, and in each separate mail-in request, you could also get 100 points. But if you pay $1 to buy a gift certificate, you could also get 100 points. If you get $10, you could get 1,000 points, and you could multiply by 3. You could multiply to figure out the more money you pay to buy gift certificates, the more chances you have to play in reward games, the more chances you potentially have to win in chance-based games. And you want to getting back to whether or not chance predominates in Crazie Overstock design.
But before you go there, let me ask you a real quick question about when you play the reward game here with your game points, whether they're free or whether you purchase them. Is there any skill at all involved in determining what the reward is going to be in the reward game?
No. There is no skill involved, and that's not a matter of a dispute. So plaintiffs, experts, the state, the trial court, the Court of Appeals all agreed that reward games are predetermined by a machine. So no use of skill changes the result of your reward play.
And when you go to the dexterity game here, is that always to determine what part of the predetermined reward you get, as opposed to you can't get more than what that predetermined reward is, can you?
That's exactly right, Your Honor. You understand it 100% correctly. So what you are playing for, you could reduce what you have won through reward games that are casino-style games, but it's always a portion of that. It's never more than that. And Your Honor, I think you asked in a previous case, you asked a really good question about can you reveal a prize without actually going to your dexterity game? And I think that's an element in our case that highlights how a chance predominates here. You cannot bypass reward games in this situation. You always have to play them before you proceed to a dexterity game. But if you wanted to bypass a dexterity game, you could. You don't have to engage into playing dexterity game. You could take all of your winnings at your reward games and put them all towards playing reward games again. That is the way this system is designed. And you could, try to maximize your winnings. So chance is clearly elevated in this design. It encourages the type of repeated play that the legislature was trying to eradicate through this statute. And of course, once you get to the element of the dexterity element, this final element of sweepstakes, it is the element that, based on plaintiff's own expert, 96% of people could pass. So the skill that is involved is that little. It's not state's, it's not state's evidence. It's Crazie Overstock's own evidence. So
let me ask a quick question about when you said you could skip the dexterity part of the game and turn your reward points into additional game points?
Yes, exactly right.
Could you turn those reward points into cash?
You cannot. What you could try is then to use those reward points and again through playing casino games to maximize your winnings possibly, or lose it all. So that's where, again, the system is set up where it maximizes your gaming, your casino style experience. So
to translate, I'm sorry, Justice Hudson, were you through?
I'm done.
Okay, I was just going to ask, in terms of translating much of this, if we've heard a sufficient amount of at least where the state is, for translation purposes, how does this translate into the state's position that there is no genuine issue as to material fact?
All the elements on how this system operates are agreed on by both sides. You pay, the more money you pay to buy gift certificates, the more entries you get to play reward games, which are casino-style games. That's all agreed. When reward games, casino-style games, are games of chance, that's agreed by the parties. Reward games do allow you to play dexterity test, which features an element of chance, but 96% of people are successful in that chance element. So that's a fact that is agreed on, and you could cash out at the end of this sweepstakes system. That is also the fact that is agreed on. On these facts, on these undisputed facts, the only conclusion that the court could arrive at using Sandhill's test and other gambling cases in our state, the only conclusion is that chance predominates. Your Honor, video poker and video poker, which feature more elements of chance than this game. Poker features bluffing. Poker features human psychology evaluation, statistical knowledge. It's a game of chance in North Carolina. If that is so, what other fact could change the system design that could lead the court to a different conclusion? Undisputed facts warrant the summary judgment, and the trial court correctly found that the state is entitled to prevail on video sweepstakes statute.
Does chance predominate because the skill aspect does not change the percentage of the winnings, or does not change the amount of the prize or the value of the prize, or is it a combination of all that, or should those be isolated as individual circumstances that lead to the state's position?
Critically, the price is predetermined. That's a very important feature, just like it was in Sandhill argument before you. But you could evaluate this system holistically too, and you will arrive at the same conclusion for the reasons that I just outlined. That you could bypass the skill entirely and play casino-style games all day long, and the fact that reward games are purely games of chance. So you could rely on the price to come to a conclusion this is a chance-based system, or you could incorporate all of the same factors and still would come to the same conclusion.
What's your response to the other side's position that we should be focused on as a court the final outcome as opposed to the elements upon which you would like us to focus?
The way they describe the final outcome is not the way Justice Irvin described the word final outcome in Sandhill's decision. And to kind of give a bullet point response, to that argument, it's contradicted by Sandhill's. It contradicts the legislative intent to make sure that these pretextual types of design where you throw the element skill towards the end of the test, that they don't end up in decisions that legalize what otherwise amounts to illegal gambling. So, and finally, it is not grounded in any statutory language. If you look in the statute itself, in 306.4, there is nothing that talks about final element has to be skill. Nothing at all. That is, so it's just not the correct interpretation. And under the predominance test, we prevail. But I also wanted to talk
before you move on, I do want to make sure I understand your interpretation of the statute. And so, is it your interpretation that there are some sweepstakes games that would be legal under the video sweepstakes games that would be legal under the statute?
I could give you an example, even from this case. Take out the chance games, take out the casino game, style games. You get a sweepstake and you get to engage into just a skill component where everybody is entitled to play dexterity test, but there is no casino style. I don't think this statute is going to prohibit that design. Okay. So I also, I think my colleague in his previous, in his argument before this case gave you an example of teddy bears. I do think it's a very, it's a valid example of other design of sweepstakes that could be legal under the broad reading of this statute. I would like to address briefly, and I'm happy to answer video sweepstakes questions too, but I know your honors heard it whole morning. I would like to address a little bit the pretextual nature of these games too, because under the state's alternative argument, the court could find that Crazie Overstock is also violating other gambling statutes, satisfying consideration, price, and chance requirements, the traditional gambling statutes. And what we argue is that the court in Hest has announced that in a situation where business is, selling products and then using video sweepstakes to promote those products, but those products are being wasted, being not used. And Hest Court, Justice Hudson, you cited to Vento, Telesweeps, and Davis, the three cases, discuss situations where like internet time was not used and telephone cards were not used, even though that they had some legitimate value to them. In those cases, businesses are engaging into pretextual gambling, camouflaging as real businesses, but not really selling products. And this is the situation that we have here. And our brief, pages 60 through 63, summarizes the evidence that was developed in this case. There are some months, Your Honor, where Crazie Overstock earned millions of dollars in revenue from selling gift cards. But at the same time, only 3 purchases or 3 redemptions of gift certificates would occur. This is a kind of evidence that Hest was discussing, as evidence that allows the court to find that there is pretextual gambling going on.
If I understood your colleague's response to that argument, he basically said, well, first of all, you should look at whether there were legitimate products. If there were, and he contended that that was the case, then you should look at a number of other factors. Why is the evidence that you have cited in your brief with respect to the pretext issue sufficient to justify an award of summary judgment in your favor, regardless of this other information that your colleague has argued that we should consider?
Why is that record evidence allowing the court to find that this is a pretextual business? Even though
I think his argument, if I'm understanding him correctly, is that, and his colleague can set me straight if I'm wrong. He seemed to say, in effect, the first thing we ought to do is look and see whether there were legitimate products that were available if we chose to buy the gift cards, and that in addition, that there was a genuine issue of material fact arising out of this particular contention on the part of the state because of a number of other factors, including the design of the website, the fact that various other businesses didn't have on-site stock. I mean, I'm not going to be able to name everything that he cited, but I hope that will at least refresh your recollection as to what his argument was. Why do you, and his argument was, in essence, because of those other factors, there is a genuine issue of material fact as to whether we were in fact operating a pretext business or not. Why in your view, is the focus upon the numbers cited in your brief sufficient to eliminate the possibility that there's a genuine issue of material fact with respect to this question?
So there is no genuine issue of fact here at all, because we are using plaintiff's own records. So it's a matter of applying these established facts to a test that the court in Hest has elaborated. And the test is quite simple. If the products are being promoted through sweepstakes and people buy them but not use them, that indicates that something else is going on. And the fact that the products that are being promoted have some legitimate value is irrelevant at that point. They could, but what if 99% of people end up not using them, as was the case in Telesweep's Inventor in Davis, as was the kind of evidence that this court was looking for in Hest itself.
I just have a question about that point, because it seems to me this is a criminal statute. And so the public needs to understand what is legal and illegal so they can conform their behavior to it. And if what makes this illegal gambling and what makes it a pretext is not the action of the company has the website, you have the gift certificates, you can buy the products, they will send them to you. If what makes it illegal pretext and gambling is the behavior of the patrons who could redeem their gift certificates but don't, how does that give people enough notice that what they're doing is illegal? It seems to me that we're making this an illegal gambling based on the behavior of the patrons and not anything that the operators of the game is doing.
So it's not the behavior of the patrons, of the customers, that makes this business illegal. Customers' behavior is evidence of what the business is truly after. It's a piece of evidence. And in our case, and that was true in North Carolina back in 1913. In State versus Lipkin case, for example, the company really was selling furniture. In that case, as long as customers committed to pay 25 cents, at some point after they reach $17.50 in their accounting, they would get a piece of furniture that was $17.50 worth. But the company also promised patrons that in addition, that they may get a chance at some point after paying $1 or $2 towards the furniture to get something else. And that was what turned that enterprise, which otherwise would have been lawful, that promise of something else, and enticing people to throw money away to buy the goodies like that, that what turned it into an illegal gambling. And into illegal gambling enterprise. And in this case, Your Honor, it's not just the revenue versus redemption evidence that we talked about. There is also other evidence in the record that suggests that this enterprise is illegal under other gambling statutes. For example, the operating hours of the stores. the record shows some of them opened at 7 a.m. and closed at 3 a.m. The lack of basic records that the state requested from the plaintiffs, the failure to produce basic records to rebut the evidence that the state put on at the motion for summary judgment state. For example, records that would show how many total number of gift certificates that were redeemed by the customers. We don't know, we don't aggregate that information. What is the total number of purchases of gift certificates that was made? We don't know that. The lack of that basic business information adds to the state's request from the court to find this business pretextual. So it's on the totality of evidence that we ask the court to conclude, just like the trial court did, that the enterprise is simply camouflaging as legitimate business. We also ask the court to find that Crazie Overstock's scheme violates video gaming statutes, and it's automatic in this case if the court agrees that this is a pretextual sweepstakes enterprise. Video gaming statute would be violated under that logic as well. I would love to answer any other questions. With that, I rest.
Thank you, counsel. Rebuttal.
May it please the court. My name is Bill Bryan, and along with Mr. Anthony, I represent the appellant Crazie Overstock. All of the issues discussed by the Attorney General are addressed in our briefs that have been filed in this matter, and I don't intend to address them all again. Instead, I want to plead with this court to apply the sweepstakes statute as written and to write a clear and unambiguous opinion that will guide Crazie Overstock as well as the many other companies which operate similar business promotions going forward. Mr. Anthony and I have been representing companies which offer promotional programs and sweepstakes to encourage purchase of their products for nearly 10 years. We have been asked many times to advise companies on what the law is and how they can comply with that law. In fact, at least once a week, we get a call from a new client seeking advice simply on how it can comply with the law. Unfortunately, for the past couple of years, we've had to advise clients that it's not possible to tell what the law is in this area. True, there is a statute which is reasonably clear in its wording, but unfortunately, no court at the appellate level seems willing to apply the statute as written. Trial courts apply the statute in arbitrary and inconsistent ways, which vary wildly depending on what part of the state that you're in, and the way the law is enforced also is very inconsistent. The result has been chaotic and oppressive. Neither Crazie Overstock nor any of the people who operated stores ever been convicted by either a judge or a jury of breaking the law. And yet law enforcement continues to raid its stores, confiscate its equipment, and file fraudulent affidavits seeking the issuance of search warrants in order to try to shut it down. To say that these activities have interfered with its legitimate business operations would be a gross understatement. They have all but put Crazie Overstock out of business. We are confident that Crazie Overstock's promotional program complies fully with the terms of the sweepstakes statute and all other applicable law. And we are equally confident that if this court will apply that statute as written to the facts in this case, it will agree. As recently as March 12, 2021, this court decided the case of JVC Enterprises versus City of Concord, in which it clearly and forcefully applied all of the principles of statutory interpretation and construction that we urge it to apply in this case, in exactly the same manner in which we're urging that those principles be applied in this case. If the court applies those principles in this way, then Crazie Overstock will be permitted to continue its operations because those operations comply with the terms of the applicable statutes. If the court will approach this case by looking at the facts of the law first and then reasoning from the facts of the law toward a conclusion, rather than deciding upon an outcome and reasoning backward in order to find a way to support that outcome, as we believe the Court of Appeals did, we are confident that this court will come to the proper conclusion. We also urge you to write a clear opinion in this case that will guide both law enforcement and the public going forward. The confusing status quo that has caused hardship and has absorbed public and private resources that could have been put to better use must not be allowed to continue. Please do not adopt some other court's opinion as your own, because there are no other clear opinions from other courts to adopt. We also ask that you do not merely issue a per curiam opinion, because that will do nothing to guide the actions of the interested parties going forward. Please prepare a fully reasoned decision. If you do this, we are confident that you will rule in favor of Crazie Overstock. And if that outcome is not to the liking of the Attorney General, he can ask the General Assembly to rewrite the statute. Rewriting the statutes is the business of the General Assembly. It is not the business of the courts. Again, all we ask is that you apply the statute as written, and we appreciate very much your time and your consideration in hearing this case.
Thank you, counsel. Thank you, everyone. Madam Clerk.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina is now in recess. God save the state and this honorable court. Thank you, counsel.